Vaquera. I'm the bureau chief in Washington, D.C. I'm joined by Katie Cherkasky, former federal prosecutor, who also has a background in constitutional law, and that will certainly come in handy today as we talk about some unprecedented developments just across the street from our NewsNation bureaus here in Washington on Capitol Hill at the Supreme Court, where right now, as has been the case for about the last, 18 hours, protesters have gathered. The justices have entered through the back door. They are huddled. We've heard now from the Chief Justice of the Supreme Court, John Roberts, in the wake of the stunning Politico report. I can't remember anything, Katie, in my experience like this. Apparently it's happened, but well before my time. The leak of a draft opinion on one of the most volatile cases, one of the most hot button cases, one of the most emotional cases with tied to so much vitriol around the country, so much polarization. That is the question of abortion. The Mississippi case that the court heard several weeks ago that would have restricted the right to abortion for people in that state and banned it after 15 weeks, after the previously set precedent of viability, I believe is 24 weeks. The court heard the case, and we weren't supposed to get a decision until late June, as is usually the case when it comes to the Supreme Court when they hand down these decisions. But again, a stunning leak reported by Josh Gerstein from Politico of the opinion, a draft opinion, we should emphasize, from Samuel Alito, of course, the George W. Bush appointee, who excoriated the precedent of Roe versus Wade and said that it was shoddy. It was shoddy reasoning that led to the decision and essentially taking away or completely eviscerating 50 years of precedent, or as you lawyers say, stare decisis, the guiding principle that when the Supreme Court decides something, it's decided more or less forever. Not the case now. I just want to very quickly, Katie, before I ask you about what's going on here, the statement from the Chief Justice says, in part, to the extent of this betrayal of the confidences of the court was intended to undermine the integrity of our operations, it will not succeed. The work of the court will not be affected in any way. There is going to be an investigation by the Chief of Police of the Supreme Court, known as the Marshal. Just the fact, Katie, that the Chief Justice of the Supreme Court is compelled to put out a statement like this, which is in and of itself almost unheard of, speaks to the seriousness of the gravity of this situation, doesn't it?
Oh, absolutely. As you said, this is completely unprecedented. Now the Chief Justice has confirmed that this is, in fact, an authentic draft, right. Still a draft. Obviously, Roe is still the law of the land right now and will be until and if the opinion is issued. And of course, the votes could change between now and then. Perhaps the person that leaked this, the intent may have been to put political pressure on the court and on the justices before the final vote was reached. But of course, this is a completely unprecedented moment in time, and not just for the fact that the decision got leaked, but really the underlying rationale of this opinion, if it does in fact come to be the law. So
okay,
I think that's
what you mean by that. The underlying rationale. That's interesting. In terms of what Alito had put forward.
Right, exactly. So as many people know, this case dealt with a Mississippi law that directly challenged Roe because it essentially outlawed abortion past 15 weeks. And under Roe and under the Casey precedent, states could not put an undue burden on people seeking abortion, which was traditionally defined as around the point of viability of 23 weeks. So any pre-viability bans would have been unconstitutional before this point. So this challenge was really looked at as, hey, is the court going to actually use this to overturn Roe altogether, or are they going to be more limited in their ruling, even if they do uphold this Mississippi law?
I remember when it was argued, that was the key question, right? And so what have we learned now with Alito's draft opinion?
So as we've seen here, if this opinion turns out to be the law of the case, then not only will the Mississippi law be overturned, but really the entire issue of abortion will be left to the states, or arguably to the federal legislature, but that's kind of another conversation altogether. Yeah. But ultimately, what Alito is saying here is that the Constitution does not provide any protection for the right to abortion, that states are free to legislate that as they wish. And obviously, some states will continue to keep laws allowing abortion on the books. Others are ready to enact or to put into effect laws that exist that will automatically outlaw abortion. So this opinion goes very far.
These are the so-called trigger laws, where states that are led by Republican legislatures and governors have basically these laws on the launch pad for when and if the Supreme Court, as apparently now appears is going to, does go so far as to outlaw Roe versus Wade. One of the questions, the key questions that I have, and this, I'm a layman, I'm not a lawyer, and I'm not certainly not a constitutional scholar, and I only cover the court when things like this happen. So I'm going to ask you: is this up to the states, or is this essentially saying the federal government says that there is no right to an abortion, and therefore no state can allow abortion services or abortion to be performed at all?
Well, according to the opinion and really under the rationale that Alito uses, it would be up to the individual states. The only thing that the Supreme Court can really look at is whether there's a federal right or implication involved in a law. And up to this point, it's been identified that abortion falls under the general right to privacy. But this opinion says that that was always incorrectly decided, that really the Constitution does not provide for any sort of legislation on the issue of abortion. So then it would default go to the state legislatures. There is an argument that potentially federal legislation could come up if it were to be able to be passed, which doesn't seem very likely, that could override state authority on the issue. But the default would be that since the Supreme Court says the federal government cannot legislate on abortion because it's not part of the Constitution, then there would be just a state-wide ability to regulate this. And we can see that because you've seen the Texas law, for example, and that's kind of a completely different discussion. But that law basically used a workaround so that it could not be reviewed federally because there's no state actor involved in essentially dealing with abortion. So the Supreme Court already declined to review the law, saying that the state could do that because it doesn't involve a state actor. So there's no federal jurisdiction.
Right, and that's the one. That's the one where private citizens can essentially sue or bring some sort of legal action.
Right, exactly. And which is interesting. And I mean, a lot of states have kind of taken a hint from that. So in terms of the nature of this decision, it's not particularly surprising because abortion was kind of being chipped away at in these states that didn't want to have that on their books anyhow. And the Supreme Court was essentially allowing that. But this Mississippi law is really a direct challenge to what Roe said, which is that states could not put an undue burden before the point of viability on an abortion decision, and this completely obliterates that.
All right, that's amazing. I want to back up just for a second and get a little bit in the weeds on the Supreme Court itself. You know, we in Washington and in the legal community, we're shocked by what happened here, by this leak, because it never happens. I mean, there have been cases in the past. The actual, I was reading this morning, the actual original Roe versus Wade decision, not a draft, but the decision was leaked just a little bit before it was actually handed down. But why is it so important that the integrity, why are people saying the integrity of the court is at stake because of this leak? It seems like if you're not familiar or if you don't have an appreciation for the way the Supreme Court is structured and set up to be sort of almost a monastery, set apart from the changing winds of politics in the country and the fickleness of public opinion. So why is the integrity of the court threatened by this leak?
Well, that's exactly the reason. The court is supposed to be apolitical. Obviously, with the appointments of justices, it seems anything but that because we have all their ideologies and we think we know how they're going to vote a certain way and they make certain promises or soft promises when they're getting confirmed. But ultimately, the court is supposed to be the branch of government that is apolitical and makes decisions based upon the law. This leak seems to be, and again, they have no idea at this point, at least as far as we know, where this came from, whether it was from somebody on the right or the left. But if it were from, let's say, someone on the left, it looks like maybe an attempt to politicize this or to get some sort of reaction from the public before this becomes law, which could maybe impact the ultimate vote on this. And that is not the point of the court, ultimately.
To try to sabotage the internal process of the court. It's amazing. And the way this goes is the court hears the case, in this case, the Mississippi case, and then the justices, correct me if I'm wrong here, the justices huddle together. They have a meeting. I guess I would assume they have their law clerks there as well. They talk about the case, their opinions of the case. Some sort of informal, I don't know if informal is the right word, but preliminary vote is taken, after which the writing of the opinion is assigned, usually by the Chief Justice. And if the Chief Justice is in the majority, then the Chief Justice will usually write the opinion. In this case, it appears that he's not. Chief Justice John Roberts and Alito wrote the opinion. So we're in sort of the draft stage, right? And so how likely is it that this draft opinion by Alito would have made it until late June, what the public was supposed to hear in terms of the opinions?
I think that the timing does raise some questions about how much more change could possibly occur if they were supposed to be issuing this in June. It's already May.
Yeah.
And so, I mean, but ultimately, there could be people that are uncomfortable with certain language. So maybe the votes don't change, but maybe some of the language softens a bit, because the way that it's written currently is very, in some sense, radical to greatly sweepingly override all of this precedent, not just hone in on the particular law, the issue
I
here.
want to talk about this precedent issue because a lot of people have been bringing up Obergefell, the case that legalized same-sex marriage in this country, other cases involving rights that the Supreme Court has granted through its decisions, even going all the way back to Loving versus Virginia, because Virginia in the 1960s, up until the 1960s, had outlawed interracial marriage. So can this precedent, this logic and this legal reasoning being applied by Alito and the majority be applied to some of those laws?
Well, that's obviously the concern here, because the right to abortion, and I think that it's more nuanced than some people are maybe even aware of, it really falls under the broad interpretation of the right to privacy, which is why the Supreme Court said that they were able to regulate what states do with that particular issue. And the same could be very well said about the right to same-sex marriage and things that are really private decisions that the court has interpreted as being covered by the Constitution, even though they're not explicitly listed in the text of the Constitution. So the interpretation of what the Constitution allows the federal government to regulate could be at risk here. If the court is willing to go to this level with the settled precedent, or so we thought, of Roe and Casey, then clearly they theoretically could, and they always could, but we've never seen them go this far with something that's been so settled. So I think that that's a valid concern, that there could be potentially a re-looking at some of those other cases that were kind of interpreted as being broadly covered by the Constitution, even if they're not explicitly rights that are delineated there.
That's remarkable. And Democratic senators and the Speaker of the House and others today are talking about legislative remedies, federal laws to codify the rights granted under Roe, which apparently are now going away. This might be a little bit in my bailiwick, but I'll ask you too. What needs to happen in Congress for this apparent decision, again, a draft that we know of, to be reversed? Leaving aside the question whether it's politically possible for Congress to do it at this point, what would be required by the national legislature, in other words, Congress, in order to fight back if Democrats chose to do that?
Well, there has been some proposed legislation that would essentially codify Roe, which would protect the right to abortion nationally, and it would take the right away from each individual state. But as you mentioned, practically speaking, the votes are not there. That there's been talk about removing the filibuster, because in order to get even to a vote, there would have to be at least 60 votes, and there just doesn't have the numbers right there for that. So there's been discussion about that. I think that there's even some Democratic senators that are uncomfortable with the current proposed legislation. So I think for practical purposes, if there was some sort of legislation that was a little more moderate, that potentially they could garner more support. But it is possible that there could be federal legislation on the issue that would then override essentially any state laws that were contradictory to that. But for practical purposes right now, that's not possible. So I think that's why a big push on the Democrat side is for the election purposes to, up their numbers there and maybe re-explore that option.
Right. We've heard from the President of the United States today. He's on his way to Alabama to visit a factory that makes Javelin missiles that have been so successful in fighting back against Russian tanks, in particular in the war in Ukraine. But he was asked by reporters out at Andrews, Joint Base Andrews outside of Washington here, if he was do away with the filibuster to codify Roe. Speaking of codifying. So in other words, the filibuster would allow a simple majority, getting rid of the filibuster would allow a simple majority to pass the Senate codifying Roe. The president says he's not prepared to make those judgments now, but codification of Roe makes a lot of sense. The idea that we're going to make a judgment that no one can make a call to abort a child based on Supreme Court, I think, is way overboard. To me, I mean, someone who was a senator, I can't remember how many, 46 years, who has in the past spoken forcefully against so-called filibuster reform. In other words, he likes the filibuster. It seems very unlikely. That seems like a non-committal answer that he's not going to support getting rid of the filibuster, leaving aside the question of whether Joe Manchin and other Democrats would go along with getting rid of the filibuster at all, which it doesn't appear that they would. So it's almost a moot point. There's also talk of expanding the court, allowing a Democratic president along with a Democratic Senate to essentially pack the court with more Democratic nominees and tip the balance that way. What's your view of all of these efforts at reform, a structural reform at the court, and whether it's possible? I know it's been tried in the past by FDR. It didn't work out very well.
Well, I don't think that Joe Biden, and I did hear his remarks today, seems particularly interested in any of those kind of extreme measures, because it cuts both ways. I mean, obviously one party's in control now, but in the future, that's the other way around. And so it can really cause more harm, and it's not such an easy, quick fix, I think, in certain respects. So to the extent that that Joe Biden doesn't seem that he's interested in those radical measures, I also think that there's a lot more to it than just kind of the immediate legislation that's at issue here. So I think there's a bigger picture that they're looking into. I know Elizabeth Warren really supports removing the filibuster and says that the Republicans have really gotten much of what they've wanted anyway, so she doesn't see a huge risk to that. But I think that might be a bit short-sighted in my opinion. So I think ultimately this is from the federal legislative standpoint, I think it is a voter issue more than anything else. Okay. This has been kind of, the tea leaves have been read for quite some time with the conservative majority on the court here, that this was going to come down. But unfortunately, it's
a great point. It's a great point, because this was sort of baked in. It just came in a manner that we didn't really expect, a leak unheard of. And 2 months earlier than we thought we would get it. But most people who witnessed the arguments as court watchers thought that something like this was going to happen. You've already outlined essentially the two possibilities. I want to get to a question from Frank McBride, and this is a great question, and I've been thinking about this morning myself. If the leaker is identified, how will they be held accountable? We've heard a phrase used by the Supreme Court, the Chief Justice today, the Marshal of the Supreme Court is essentially the Chief of Police, lead an investigation. But is this a crime?
Well, it's an interesting question. I've thought about it. And, there are certain federal statutes that criminalize unauthorized access to government computer systems or wrongful use of materials that are taken from there for improper purposes. So I think that would be the most likely criminal statute that would apply if they were to identify this person. But ultimately, it seems more of kind of an employment issue, really, because there's certain authorizations that you have working in certain places. But on the criminal side, I think that unauthorized access to government computer systems or something along those lines could be a potential criminal charge that could come from this.
Right. But it wouldn't be directly an anti-leaker or confidential, are such laws on the book? I mean, the Pentagon Papers was a good precedent back in the 70s when Daniel Ellsberg leaked voluminous information about the Vietnam War, and
Sure. I mean, if there's classified information or anything that has any sort of classification level, obviously and that would be a different statute that would be implicated. But I think really depending on the circumstances of how this was leaked, that will really tell us what, if any, charges could be pursued by the DOJ.
Okay, Frida Heron asks, what can Democrats and opponents do to fight back against the ruling? I think you and I talked about this a little bit. I just want to point out that it's interesting to watch the reaction, if you can, and this doesn't necessarily cut cleanly along party lines or religious lines for that matter. But the Republicans, by and large, Mitch McConnell on the floor of the Senate today, when they open the Senate, traditionally the leaders make speeches, railed against the leak. He didn't talk about the underlying issue of abortion as much as and you hear this from a lot of Republicans. They want an investigation. They feel as though the court's integrity has been compromised, and they want to find out who the leaker is. Democrats, on the other hand, scheduled to happen about a half an hour ago. I haven't seen the video, or I didn't watch it live, but Chuck Schumer led all the senators from outside the Senate chamber. It was supposed to down the steps, a very dramatic show of unity among Senate Democrats. But again, there's really not, given the political realities and the simple math of the Senate, there's not much they can do, is there?
I think currently that's accurate. And if this does become the law, then ultimately many states will automatically put these trigger laws into place, and then there will be subsequent litigation that comes from that. So this is only the beginning on the legal front and on the political front as well. But in terms of future elections and the numbers changing, there could very well be, and maybe even different legislation proposed that's less extreme, because I know there's been some non-support for the bill that currently exists because it goes very far, according to some senators. So perhaps there could be something that is more amenable to more people in the future, but that would be, that's not an immediate fix for sure.
Yeah, I agree with you as a longtime Congress watcher. Bernice asks, what happens if the public loses faith in the Supreme Court? It's a good question. Is that a concern that justices consider in overturning past rulings? So I guess there are two issues here: faith in the Supreme Court compromised by the leak, or faith in the Supreme Court compromised by abandonment of stare decisis or sticking with precedent.
Sure.
Let's take the second one. We already talked about the first one. So
exactly.
We've often been told by the Supreme Court decides, that's it, that's the law of the land, we're not coming back to it. How often is that broken?
It's very rare, and for good reason. I mean, that's part of what makes our justice system reliable, and that we can depend upon certain things that when we're living here. And this is something that, even though we maybe expected that there would be some incremental chipping away of this right, to drastically, completely take it away in this manner is surprising, even for people that expected something a little less than what Roe had allowed for. So I think that the justices do consider this. I think that that's explained in part the length of the decision and the explanation. They are not prohibited from overturning precedent. It's just that's the policy, that's the preferred policy. But ultimately, they have to make those decisions if they believe that there's what they would consider an error in the law. To continue to perpetrate that would be against their philosophy. So
that draft opinion from Alito, 60 pages, again, as reported in Politico, a remarkable set of events, and the aftermath of this, the aftershocks, really are going to be felt not only today, but for the foreseeable future, because there's so much at stake here. I just want to wrap with this one question, Katie, and that is, what's next? What happens now? I guess we have to take it at face value at this point that this is going to be what is officially decided when it is officially the decision date of the Supreme Court in late June or early July.
Right, exactly. So like I said, right now, Roe is still the law of the land and will remain so until this opinion is issued, if it does in fact follow along with the draft. And so, you can expect a lot of protesting and political pressure, I'm sure. Whether the justices will be impacted by that remains to be seen. But there's been talk of this for a long time. And unfortunately, I think that there has been pretty good knowledge that this was coming down the pipeline. So people have been preparing to fight this, both on the political side and then legally. Like I said, there's going to be plenty of lawsuits that follow, for sure.
All right, Katie, I think we're out of time. We've taken a lot of it. Katie Cherkasky, former federal prosecutor and constitutional law expert, thank you very much. I learned a lot with our discussion, and it is something that we're going to be talking and thinking about over the next hours, days, weeks, months, for quite a while. So thanks.
Thank you.
All right.